Arbitration Week event on international law and the war in Ukraine, co-hosted by Sherman and Sterling and the Ukrainian Arbitration Association. My name is Jennifer Ewan, and I'm a partner in the International Arbitration Group of Sherman and Sterling based in Paris. And I have the pleasure of co-moderating today's panel with Elena Perepolinska, President of the Ukrainian Arbitration Association, Head of Arbitration and Integrity, and Chair of the ICC Ukraine Arbitration Commission. Elena and I are extremely pleased and honoured to be joined today by two eminent panellists, Professor Jennifer Trahan and Jonathan Powell. Professor Jennifer Trahan is a clinical professor at NYU's Center for Global Affairs, where she directs the concentration in international law and human rights. Jennifer serves as one of the US representatives to the Use of Force Committee of the International Law Association and holds various positions with the American branch of the International Law Association, including as co-chair of their Committee on the International Criminal Court on the Afghanistan situation. Jennifer was also named to the Council of Advisors on the application of the Rome Statute to cyber warfare. More recently, Jennifer became convener of the Global Institute for the Prevention of Aggression. Jonathan Powell was Chief of Staff to Tony Blair from 1995 to 2007, and also Chief British Negotiator on Northern Ireland. He's worked on various conflict negotiations throughout the world, including with ETA in the Basque Territory, on the negotiations in Colombia with FARC, and on the peace negotiations in Mozambique. Jonathan is CEO of Intermediate, the charity that he founded in 2001 to work on conflict resolution around the world. He's also recently co-founded Datras Mediation, whose mission is to mediate global disputes between private and public actors on many of the issues that we've discussed during Paris Arbitration Week this week, issues such as climate change and inequality. So we can probably expect to see a lot more of Jonathan in the investor-state dispute sector. I'm going to pass the floor on to Elena to briefly outline the topics that we plan to address today. But before I do, let me encourage the online participants to try to engage with us throughout this webinar by using the question and answer function at the bottom of their screen. And please feel free to pose questions throughout. The session will follow a question and answer format between the moderators and the panelists, and then we will open it up to questions from the audience. For those online, we will endeavour to pick up your questions throughout the webinar and pose them to our panelists. So without further ado, Elena, have the floor.
Thank you, Jennifer, for this introduction. Good afternoon, everyone. So 36 days ago, on 24th February, Russian troops invaded Ukraine in blatant violation of international law. On 2nd March, United Nations General Assembly overwhelmingly by 141 votes, adopted a resolution demanding the Russian Federation immediately end its invasion of Ukraine and unconditionally withdraw all its military forces from Ukrainian territory. However, Russia ignored that resolution and continued killing Ukrainian children, civilians, destroying civilians' objects, and committing other crimes in Ukraine. So today we will talk about international justice, crimes, and accountability for those responsible for these crimes. And accountability is important not only as a matter of justice, but also to prevent such crimes in the future. As Putin's blitzkrieg failed just on the second day of this war, he, during his call with Xi Jinping, said that he was already ready with Ukraine. And notably, the General Assembly resolution about Russian aggression also urged the immediate peaceful resolution of this conflict through political dialogue, negotiation, mediation, and other peaceful means. So today we will also talk about negotiations as a tool to achieve the most realistic let us start with the issue of international justice first. So Jennifer, the floor is yours.
Thank you. It's a great pleasure to be here. And I think you wanted me to first explain the field of international justice. Why do we have this field? And I'm going to start with a quote from Reed Brody, who I used to work with many years ago at Human Rights Watch. And he said, if you kill your neighbor's chicken, you owe them a chicken in return. If you murder a person, you face prosecution in the domestic system. But if you are implicated in 40,000 cases of torture, you go into exile in a neighboring country. And that's really the difficulty that in past vast atrocities simply escaped prosecution when your ordinary cases might find it. And it is similarly the failed prosecutions after World War I and failed and minimal prosecutions in Turkish courts for the Armenian genocide. And that, let's see, we're having a lot of paper sound on the Zoom. I don't know if someone can mute them. So it might be you, Jennifer. I don't know if you can mute. So this is the theory that sometimes these cases just evade domestic courts. I think maybe we've come somewhat full circle and said, we need these tribunals to prosecute the most horrific crimes. But there's also a role for domestic prosecutions. And the idea of an international criminal court is to have one institution. We started this field with the Nuremberg prosecutions in Tokyo, and then creating these separate tribunals, Yugoslavia, Rwanda, Sierra Leone, Cambodia, and then decided this was, hardly an efficient way. So we should have one standing institution. And the court has now opened an investigation into the situation in Ukraine. It received an unprecedented 41 referrals by states parties that they wanted this investigation to commence. This is really unprecedented. In the past, we've had referrals by either one state or 5 states was the most numerous, with the Venezuela referral. So this is really an outpouring of support. And this is warranted. There's, I will say there's some slight concern that governments are saying it does come down to budget. I know this is very prosaic, but for International Criminal Court, it didn't budget this situation. States are now pledging extra funding to the court. I think their prosecutions are, extremely important. But I do, and I'll just say, I have some concern that some states are saying, but we are earmarking this for the Ukraine case. And I understand the impetus, to give the money, but we actually should give it to the general budget of the International Criminal Court, and you should support the entire institution and not pick and choose. And I'm only worried in the future, the optics of kind of picking and choosing. We support this investigation and not that one. So I think that is something one has to be concerned with. Of course, the International Criminal Court won't be alone. And Elena, I think you had a slide of the prosecutions. The Ukrainian National Prosecution Service or investigations they've started to open into. So these would be the framing under Ukrainian law, so not the International Criminal Court, but crime of aggression and war crimes, the main case of aggressive war. So at the International Criminal Court, there's jurisdiction for war crimes and crime of aggression. So I think the latter two, crimes against children and crimes against national security, those would be under the Ukrainian code and not what the International Criminal Court would be looking at. I mean, just to say the International Criminal Court, we've seen, absolutely horrific instances of you know, when one apartment building is hit, one thinks, oh, it could be an error. But when you just have this blanket campaign that seems to be indiscriminately targeting civilians and civilian objects, for any who don't know, deliberate targeting of a civilian, deliberately targeting a civilian structure, these are war crimes, as is excessive use of force, collateral damage. And we see indiscriminate use of force. So I think all of these are going to be war crimes that the International Criminal Court, as well as some national jurisdictions, will be investigating. We're seeing also reports of sexual and gender-based violence, some reports of Ukrainian forces committing summary execution of captured Russians, so that potentially could be war crimes on the Ukrainian side. The court would have jurisdiction over both sides, and it would have, the International Criminal Court would have both individual criminal responsibility and command responsibility or superior responsibility. This goes up the chain of command, and this is what potentially goes up from commanders in the field to the top level, which would be potentially Putin himself. The International Criminal Court will have its hands full, as will national courts. I think there are about 8 national jurisdictions that have open prosecutions. And these are extremely significant because the International Criminal Court really can't do it all. It was designed to do actually a few cases in each situation country. And it's got situation countries from Philippines to Venezuela to Burundi to, I mean, it has a really, really full docket. I mean, it's just finished the trial of Dominic Ongwen for crimes in northern Uganda. So the International Criminal Court, despite probably expectations that it's going to do a huge amount, isn't really set up to do that. So it will be important for national jurisdictions to also play a role. Now, you've probably all heard that the International Criminal Court doesn't have jurisdiction over the crime of aggression in this instance, and you're probably curious why this is. So first, to say a little about the crime of aggression, where does this come from? It comes directly from the Nuremberg and Tokyo tribunals, and it is the idea that if we don't have the war to begin with, we don't even get to the issue of war crimes. So in the Nuremberg judgment, the crime of aggression is actually deemed the supreme international crime, because it contains within itself the accumulated evil of the whole. So if we don't have aggression, we don't get to the war crimes. And Justice Chief Prosecutor Keenan at the Tokyo Tribunal, in his opening statement, said these proceedings could have far-reaching effect in the peace and security of the world. Our broad aim is the orderly administration of justice. Our specific purpose is to contribute all we soundly can towards that end, the prevention of the scourge of aggressive war. So that's the idea behind the crime of aggression. It was put into the International Criminal Court statute in Rome in 1998. So the court has jurisdiction over genocide, war crimes, crimes against humanity, and the crime of aggression, but it has a more limited jurisdictional regime. And unfortunately, the US carved out the nationals of states not parties to the International Criminal Court statute completely from the crime of aggression's jurisdictional regime. The US obviously thinking of its own interests, but that is now what has carved Russia nationals out of the International Criminal Court's jurisdiction for the crime of aggression. And the UK and France then further narrowed or arguably narrowed jurisdiction in 2017. So that's kind of where we are. And so in terms of war crimes and accountability moving forward, I think there's a tremendous demand for justice. You know, we have the International Criminal Court, we'll have national jurisdictions, and the Human Rights Council has deployed a commission of inquiry that the commissioners have been now named, and they will be going and investigating the crimes. So there's going to need to be, after this is all resolved, and Jonathan is going to talk about how do we possibly, I'm almost in some ways part 2, accountability, which starts now, but the prosecutions will come in future years. So for war crimes, I think we see where the prosecutions can occur. There are potential immunities issues at the domestic level. These would not exist at the International Criminal Court. So that is the most promising institution for prosecuting kind of up the chain of command. But on the crime of aggression, it is less clear where this crime could be prosecuted. And I think in future, the International Criminal Court state parties would look towards amending the jurisdictional regime and making it not so narrow. Currently, only 43 states have ratified the crime of aggression amendment to the International Criminal Court statute. And if the UK-France reading of the 2017 resolution that activated the crime is correct, it would mean the court only has jurisdiction when aggression is committed by these 43 states. That's not enough. A number of the states are countries such as Samoa and Liechtenstein. These are not really our concerns on the international arena. So I think this is a moment for reflection. Do countries actually believe that the crime of aggression has central role on the stage? And just to say, for those who don't know the definition of the crime, it is a fairly conservative, limited definition. It only covers political or military leaders of a state. So it doesn't cover ordinary soldiers. It probably doesn't cover midway up the chain of command, only really the highest levels. And those who are in the position to start the war. And it covers broadly use of force contrary to the Charter. And the definition very much is based on Article 2.4 of the UN Charter. So the central prohibition against aggressive force in the UN Charter is the basis for the definition of the crime. And then it has this carve out that, or additional threshold, that the crime must involve a manifest or super clear UN Charter violation. And this is put in there to exclude gray area cases. And I would say what we're seeing today is not a gray area case. So we've seen Russian claims, oh, this was a necessary war because we were threatened by NATO's expansion. Well, you don't get to go to war because you're threatened by NATO's expansion. Like that there's no legal theory there, okay? And the other specious argument we heard was that there's genocide occurring in Donetsk and Luhansk, and now the International Court of Justice has put that to rest. There was no genocide occurring. That can't possibly, even if there were a supportable legal theory there, it can't possibly apply in the current situation. So this is a super clear instance of the crime of aggression. And this is really what the court statute is there to cover, and requiring, as I say, a manifest charter violation means that areas in a less clear situation, and I know there's some legal theories out there. Is humanitarian intervention allowed? Is it not? Where would that fall? It's precisely with that kind of gray area in mind that the definition is fairly conservative. And I think all states parties should take this moment of reflection of the significance of the crime to, if they haven't yet ratified the International Criminal Court's crime of aggression amendment, to do so. And additional states could also join the court. And I do also hope in the United States that we use this moment for greater reflection on the International Criminal Court's importance. There's been this really complete change of opinion of the International Criminal Court in the United States, suddenly with this vast endorsement, when only a few years ago in the United States, the Trump administration put sanctions on the ICC prosecutor and on her and another high-level International Criminal Court official, freezing their personal assets and a travel ban. So that was probably the nadir of U.S. ICC relations. Now the U.S. endorses the court because it suddenly realizes, oh, it can prosecute war crimes in Ukraine. But in the U.S., we need to actually they come to embrace the rule of law more broadly, including when the court might be investigating US nationals for torture committed in Afghanistan, when there was a large-scale torture program documented by the US Senate Select Committee on Intelligence. So we are where we are. There has been momentum that we should have an ad hoc tribunal to prosecute Russian aggression. So an ad hoc approach is not ideal. Of course, this whole field started with ad hoc, Yugoslavia, Rwanda, Sierra Leone, Cambodia, and then we moved to a much more multilateral approach. So in the long run, I think we want to get away from selective endorsement of justice and ad hoc approaches, and have suggested that in future, state parties could amend the Rome Statute's jurisdiction over the crime of aggression. As to there are two kind of models being suggested for an ad hoc approach, and I guess I'll make this my concluding points unless I should also go into veto use, but I don't know how I'm running on time, so I will need some directions here. But just to finish on crime of aggression, the models being suggested, there's kind of a UK approach being suggested. I think it started with Philippe Sands, Dato Akande, and so in the academic community has kind of been more broadly endorsed. And I think it is somewhat problematic in that I think it has more concerns of selectivity that are there. It also has the very technical issue that at national levels, there are immunities issues, and this model would pool the jurisdictions of national countries together to create a crime of aggression tribunal, and you might have the immunities problems also then attaching. So a more multilateral approach, which I think would have greater legitimacy. And of course, we're always concerned justice must be done and seen to be done. So a more multilateral approach would be if the government of Ukraine and the UN agree to a tribunal. And we have very good models with the Sierra Leone Special Court and Cambodia tribunal. So this has been done, and this could try the crime of aggression. And if you had a tribunal such as this, it would not have immunities. And we have the ruling of the Sierra Leone Special Court in the Charles Taylor case. He was president of Liberia, and he came into the court and argued immunity from any proceedings before the Sierra Leone Special Court, which was a hybrid criminal tribunal, so negotiated as meant by the UN and Sierra Leone. And there was a ruling against him that there are no immunities for crimes such as war crimes, crimes against humanity, genocide, before an international or hybrid tribunal. So that's an important ruling. So if you actually want to prosecute the crime of aggression in the current instance, I think this is the better model to follow. It's the same model used with the Cambodia tribunal. So obviously the Security Council is paralyzed. This is one of the ways that tribunals have been formed, has been through the Security Council. The Yugoslav and Rwanda tribunals were formed that way. Russia has already vetoed its own condemnation of aggression. So obviously a tribunal would not be permissible. So we won't have an aggression tribunal formed through the Security Council, obviously. But if you want to do an ad hoc aggression tribunal, we do have these models. Jennifer, should I continue and talk a little about vetoes? Maybe I have taken too much of my time.
Jennifer, actually, I might have you, I think we'd like to hear you briefly touch on the veto power, because I think obviously one of the frustrations in the current crisis, where we have one of the clearest acts of aggression since 1939, is the paralysis of the UN Security Council. And I know you've written extensively on this, so it'd be interesting to hear a little bit maybe about the history, but also I think whether you consider there are legal limits to the use of the veto power.
Okay, great. Thanks for that. So I have recently written a book, Legal Limits to the Use of the Veto Power in the Face of Atrocity Crimes. And it makes the case that we shouldn't be having vetoes that block action to try to prevent genocide, war crimes, or crimes against humanity. So, and now I think a lot of my arguments should and need to also apply to aggression. So my basic proposition is, the Security Council, of course, would never, you would never expect the Security Council to endorse the commission of genocide in a resolution. And in fact, we have the ruling Judge Lauterbach in the Bosnia arms embargo case. And he said that the arms embargo on Bosnia during the war, which inadvertently seemed to have aided the better armed Serbian forces that ultimately committed the Srebrenica genocide. He said one interpretation, if the arms embargo is facilitating genocide, it would be void. So obviously you don't have, the Security Council can't endorse the commission of genocide for multiple legal reasons. But if genocide is occurring and there's a proposal to stop it, to condemn it or other measures, and there's a veto used, the veto is effectively facilitating the commission of crimes. And we recently have seen this very clearly with Russian vetoes related to Syria, where the council wanted to first, in a series of resolutions, condemn crimes, then refer the situation to the International Criminal Court. And then it had 6 resolutions trying to prevent chemical weapons use. And then it had various resolutions trying to get through humanitarian assistance. And these were all blocked. And you've got to look at this and say, wait, blockage of humanitarian assistance, how can this be the charter? Was the charter really designed to allow this? And, Jennifer mentioned going back historically, I could do a whole lecture on, the veto does come directly from the negotiations of Roosevelt, Churchill, and Stalin. They insisted on it. They called it the principle of unanimity, but they insisted on being unanimous in decisions to use force. So this was kind of why it was put in to the charter. There was a lot of pushback in the negotiations, states questioning this, but in the end, it was basically, do you want a UN system or not? You've got to take the veto power. But I would argue it was never an unlimited veto power, because it was always framed by the UN's purposes and principles, and these include respect for international law. So if we have the veto being used in a way that endorses genocide, it is actually violating other provisions of the charter. And my book argues for too long, we've seen the veto as above the rest of the system of international law. We have to stop the vetoes that endorse the commission of the crimes. And I know there is a voluntary veto restraint is endorsed by actually 122 states, including the UK and France, who believe it should not be used while there's ongoing genocide, war crimes, and crimes against humanity. The problem is 3 of the P5, China, Russia, and the US, don't endorse this. So we still have these abusive vetoes, and the clearest abusive veto we've seen has been Russia's veto of its own condemnation of aggression. So it's using one part of the charter to effectively neutralize all of the other parts of the charter that condemn its own aggression. So my book argues that states need to raise these issues, and in debates, for instance, at the UN, Canada has so far spearheaded this, making the statement that the veto needs to be used in line with the UN Charter and international law. I ultimately argue for a GA resolution reflecting on the limits to the veto. We should not see this kind of endorsement of genocide. And just to say before I end, and I will really end, that China uses it more behind the scenes, so you don't even see it because it's the veto threat. And it is what watered down all kinds of resolutions trying to alleviate or prevent more crimes in Darfur during the height of the genocide. China was watering down behind closed doors Security Council resolutions. And this is what has paralyzed the Security Council in condemning crimes against the Rohingya. Don't hold your breath for any condemnation of crimes against the Uyghurs by genocide. Clearly a slow-moving genocide with vast sterilization programs and vast internment. And this really needs to be re-examined. I ultimately argue beyond a GA resolution, the General Assembly could send a legal question to the International Court of Justice on the legality of these kinds of vetoes. So thanks, I'll end there.
Jonathan, if I can bring you into the conversation, and I was struck by a conversation I had with a Ukrainian colleague of mine earlier this week, who I think may also be in the audience, who essentially was telling me what is there for Ukraine to negotiate. As Jennifer clearly mentioned, we have an unprovoked and flagrant violation of Article 2.4 of the UN Charter. We have an innocent victim. What brings the parties to the negotiating table? When does a negotiated solution become a realistic prospect in a dispute like this? A sort of abstract question to sort of start with, Jonathan, on how negotiations work in a conflict such as the one we have here.
Thank you, Jennifer, and thank you very much for inviting me to do some of that today. If I could just say, first of all, I know Elena is still in Ukraine, and I'd just like to express my solidarity with the people staying in Ukraine and facing this outrageous attack. And the respect for the extraordinary spirit the Ukrainian people have shown, which is really remarkable and really is why the war is going in the direction it is. Now, in terms of negotiations, President Zelensky has said very wisely that most conflicts end with negotiated settlements rather than out-and-out victory. And although the Ukrainians have done remarkably in beating back the Russians, it is hard to imagine, unless Putin completely collapses, which you can't bank on, a victory. So there will have to be a negotiation at some stage. And I think President Zelensky is therefore very wise to keep trying to get negotiations going, to keep trying to get to the table, to offer the Ukrainian people the hope that there may be a way of getting to a negotiated settlement. I have to say that I see very little sign that President Putin is really engaged in these negotiations at all, or that the Russians are negotiating seriously. They have a traditional tactic of using negotiations as a weapon to try and gather intelligence, to try and push the other side to make concessions and to diffuse pressure on them to end the attack. So I do not think we're yet at the stage of anything I would describe as serious negotiations. When you look around the world, as you say in abstract terms, when do conflicts actually enter this stage of serious negotiation? It usually seems to happen when you have what the academics call a perceived mutually hurting stalemate. That does not mean just a stalemate. When I went to Libya as Prime Minister David Cameron's special envoy, I thought, oh, there's a stalemate. This means it'll be possible to solve it. It's when you have a mutually hurting stalemate that's lasted for some time, as in Northern Ireland, for example. We do not yet have that in Ukraine. Certainly the Ukrainian people are hurting. President Putin, unfortunately, is not. And the battlefield is still very mobile. So I don't think we're yet at the stage of getting into serious negotiations, but I do think the Ukrainian side is right to prepare. I can see three possible scenarios of the way this might go. The first, and the one that worries me perhaps the most, is that President Putin will use this to get to a frozen conflict. What he will try and do is gain more territory and camp on that territory, call for a ceasefire, which will be difficult for the Ukrainian side to resist because it's their people who are getting killed, and then keep this territory both in the east of the country, where he's moving his forces now, along the south, where he's trying to build a land bridge to Crimea, and possibly even further than that, and sit on that territory and use that as an open wound to keep leverage on the Ukraine, to prevent it developing democratically, politically, and economically. What he's done in Georgia with Abkhazia and South Ossetia, what he's done in Moldova with Transnistria. That's what I fear he may be planning to do, and I hope that the Ukrainian government is conscious of this in its negotiations and the way that it approaches it. The second and the more hopeful one, which I'll just touch on a little bit, is the possibility of a negotiated settlement. And the last, I think, is Putin collapsing, which might be divinely to be hoped for, but I don't think you can make your policy or plan on that basis. Just very briefly, in terms of the negotiations, I think we can look at it in terms of three layers. I think you'll have bilateral negotiations, such as those that have been happening between Ukraine and Russia, but hopefully at some stage serious negotiations. Secondly, I think we'll have negotiations between Ukraine and Western countries in particular, because they are seeking security guarantees from Western countries, some of which are unrealistic to think Western countries are going to give. So there's going to be, if you like, a three-way negotiation: Russia, Ukraine, Ukraine and the West, particularly the United States and Russia. And then there'll be a larger negotiation, which will be about a new European security structure, because whether Putin stays or whether Putin goes, we're going to need to rebuild something like the Helsinki structures that helped us in the Cold War, something like a conventional forces agreement in Europe, intermediate nuclear weapons agreements, and of course, a new relationship between Russia and NATO. I won't go into the substance of these things now. We can talk about these in terms of the guarantees, neutrality, and NATO. There are a bunch of things to talk about, but one of the things I think is important is for the Ukrainian side to put forward a positive agenda, not simply to react to the Russian agenda. There's a danger of simply responding to what Russia wants in terms of not being in NATO, neutrality, limitations on their weaponry. And we need to also talk about some of the things we've touched on now, like justice, like reparations, and of course, sovereignty and territorial integrity. But I'm happy to go into that and the third parties if that's useful.
Jonathan, I might pick you up on that. I mean, what would Ukraine's positive agenda look like? And then you've picked up exactly our concern, having heard from Jennifer. How do you factor in transitional justice? I mean, we've talked about various paths to accountability. The ICC, the International Criminal Court, is investigating this. We may have a special tribunal. We may have domestic courts looking at this through universal jurisdiction. It's before the ICJ, it's before the European Court of Human Rights. How does that factor into any discussion, any negotiated settlement?
Well, at the moment, it doesn't factor in at all because the Ukrainian side have not put it on the table. I think it will be extremely difficult to persuade Putin to take seriously anything about justice because he never has in the past. I think likewise in terms of reparations and rebuilding Ukraine and the huge, massive damage that's been done to Ukraine, I suspect he thinks that the EU is going to be paying for that rather than him. But I don't think they should be left off the table. I think they should be discussed. They should be part of the negotiation. I spent a long time on the Colombian negotiations with the FARC, working with President Santos. And there we had this same issue about justice, that on the one hand, you cannot let victims be left with their situation unaddressed. It's just not conscionable to allow that to happen. So there has to be some way of addressing that. Equally, you do not want justice to be the only objective and to actually let justice get in the way of peace. You know, if you approach the leaders of the FARC at the beginning of a negotiation and say, you're going to jail for 35 years, they're not very inclined to sit down at the negotiating table. So you have to get a balance. And that's what we tried to do in the Colombian negotiations between transitional justice and a peace agreement. We managed to get to a balance that some people will find difficult and unpalatable, but did work in ending a war that had cost 500,000 lives, more than 500,000 lives, and sent many millions into internal exile. So I think this issue of justice has to be on the table, as does the issue of reconciliation. And it has to be part of a settlement at the end. But I think we should be realistic about how far it's going to be possible to press that with Putin if he remains in power, if we want to get to a peace settlement that stops the Ukrainian people being killed and prevents it ending up in another frozen conflict that leaves Ukraine in a very, very difficult position for a long period of time.
Jonathan, I think one of the important issues for Ukraine in this war and in this negotiation is the issue of security, because we all understand that whatever we agree now with the Russian Federation, as we cannot have confidence that they will not attack us again. And of course, we need to somehow establish a new security mechanism in order to prevent this happen ever again. What kind of guarantees could we seek from other states in this situation?
A very good point, Elena, and that's the point they have been discussing in Turkey and in previous parts of the negotiation. I'll come to the substance. My worry is these issues are often a matter of sequence. One of the mistakes that President Poroshenko made in the Minsk negotiations leading to the original Minsk agreement in 2014 was he got himself trapped by Russian tricks into a series of steps he could not fulfill politically in Ukraine. And that was a matter of sequence. Which step came first in terms of elections? It's very important the Ukrainian negotiators do not allow themselves to get trapped by sequence again. So if they're going to agree to give up on their ambition to join NATO, which President Zelensky has already made public, it is crucial that they think through what they mean by neutrality and what they mean by security guarantees. What they've asked for publicly, they call an Article 5 guarantee under NATO, of a NATO type, from Western countries. But they've actually added to Article 5 by saying it has to happen within, I think it's 36 hours, has to include closing the airspace. My fear is that they may go down this path with the Russians, but they haven't yet addressed this with the West at all. And these guarantees, I think, are very unlikely to be on offer from the Americans and others. They will argue, correctly, I think, that they cannot deliver security guarantees like that if they cannot base forces, cannot have joint exercises inside Ukraine. So I think they have to be more thoughtful about the kinds of security guarantees they will ask for. They need something quite different from the Budapest Memorandum, which was firstly outrageously not observed, but secondly was a political understanding. So I understand why they want a legally binding guarantee in this case. They've specified in their proposal that it should be a legally binding guarantee which is ratified by all the legislatures around the world who are giving these guarantees. And I note that the US Senate hasn't passed a treaty hasn't ratified a treaty for many a year, and it's unlikely to ratify one this time. So again, I think they're going down a blind alley there. They do need something that is legally binding. They should not specify how Western governments are going to make it legally binding. I think it's well worth them thinking more about the European track. They've been specific, they want the European track left open, and the Russians will not be able to veto it. Eventual EU membership includes security guarantees. Now, no one expects Ukraine to enter the EU soon, but they're in the maximum position of leverage on the EU now. This is when they should be pressing really hard to get into the EAA, this outer area of economic issues. There's no reason why they shouldn't be able to do that. And they should be pressing very clearly for candidate status and for the things that go with that. That route is more likely, I think, to give them security guarantees, coupled with more convincing guarantees that are legally binding, but will be less than they are seeking from the Americans and others. But they also need to think about how Ukraine can defend itself. They need to be the sort of hedgehog type of defense that will make Russia very unkeen to try again, given the extraordinary spirit Ukrainian military has shown with relatively limited weaponry. They must be allowed to buy the weaponry they need from the West, high-tech machinery. They must demand things like Iron Dome and other equipment like this as part of this. So when they talk about neutrality, I think it must be armed neutrality. But this whole nexus of issues is interconnected. What worries me about it is they're entering into this in very difficult circumstances, operating from a bunker and trying to negotiate on something very, very complicated when it needs a lot of thought. And I just hope the Russians don't take advantage of it again, as they did in 2014.
Yeah, indeed. These days we have received a lot of political statements. We have heard from different states discussing this new mechanism of security guarantees. And of course, President Zelensky has also mentioned multiple times that we do not want the second Budapest memorandum. We know that it's does not worth of paper it is written on. And we also heard from, for instance, that Israel has advised us to use their model of neutrality. So probably is closer to what you have just described. And we have the UK and Germany and other European states actually reflecting or reacting on this invitation. But I'm not sure whether we all are understanding, like literally, yes, what they are reacting on and what they are talking about, but it's clearly that the majority of these Western states are not going to provide something like fifth article of NATO, but Ukraine says it does not seek any similar mechanism, and that the mechanism Ukraine is discussing now is a bit different. But again, no, the draft text has not been published yet, and it's difficult for the lawyers to discuss that. Jennifer, you want to jump in? I see you. Yeah.
I don't need to jump in the middle. There was one thing I was going to respond to, but I think
no, I just wanted to, in the context of this negotiation of security and more broadly, I think it brings us also to some strengths to the negotiations, because As we understand, there is no one internationally discussed draft. I mean, it's a kind of bilateral negotiations. It seems, at least from the public statements. Jonathan, can you tell us a bit more about this?
Yes, I think this is a mistake. I mean, I think that, again, a totally understandable mistake, given the circumstances Ukrainian government finds itself in, trying to negotiate in the middle of a war when they personally are under attack and at risk of being killed. But I think putting yourself at the mercy of the Russians by having relatively informal, loose conversations by video, and then going to Turkey and having negotiations of that sort is quite dangerous. I think they should be thinking, as I said, about this as a three-way negotiation. They need the Americans, the Brits, the Europeans, and others at the table as well, if not in the talks, as a sort of group of friends of the negotiation, because they will not be able to get those security guarantees without the participation of those states. Equally, what Russia wants is the lifting of sanctions, and it's not going to get the lifting of sanctions unless those states are consulted. It would give the Ukrainian side much greater strength if you had either a group of friends working alongside a bilateral negotiation, or I worked many years ago on the 2+4 negotiations on German unification, where you had the two Germanys and you had the four guaranteeing powers. That gave, again, strength, particularly to West Germany in those circumstances, and I think it would give strength to Ukraine. So I worry that they're not thinking these things through, and they're not thinking through, too, the links between the things they're going to agree with the Russians on security and a future European security architecture. If we have a conventional forces agreement, that will have very great relevance to what happens in Ukraine about where forces can be based, about the right to inspect them and so on. And so I think they also need to think about that longer term perspective and the way that it will impact on what they agree bilaterally. So I hope they're going to use the bit of a pause they have at the moment to just rethink the structure of this negotiation and make it much stronger from their point of view. Otherwise, the Russians will do their usual sort of bullying tactic of forcing them into something that will be completely wrong for them. In these circumstances, it may be very hard to convince the Ukrainian people of, because President Zelensky has committed himself to a referendum. And if you think about how a referendum works in a negotiation like this, if you agree to the steps and you say you're taking it to the people, then the Russians are going to say, well, we don't agree to it either until you've had your referendum. We're not going to move our troops. And you'll end up with the Russians staying there. Then the referendum may fail and you'll be back to square one again. So I think, again, this political aspect of it needs very careful thought. And what I can see from opinion polls in Ukraine is, while people are prepared to consider this issue of neutrality and NATO if there are security guarantees, they are not prepared to make concessions on territory when they've spilt their blood defending that, trying to prevent it happening. So I think a lot more thought needs to go into the structure of these negotiations and the strategy in which they are approached.
Jennifer, did you want to step in with a comment?
Yeah, I just wanted to maybe respond to Jonathan's remarks only in one area. I hope accountability is not part of the negotiations. Accountability is coming. And I think putting it on the negotiating, so I'm not a negotiator, I'm a, so my opinion from the justice perspective, accountability is something you can't negotiate away. And if you put it on the table, it suggests you can negotiate it away. And I don't think anyone has, there are certain crimes that, that absolutely should never be negotiated away. And I don't know that attempts to negotiate them away would even be valid. So the Bosnia peace negotiations in Dayton, were silent on accountability. And then we did have accountability, most certainly. So, I realized it worked in, to the extent it worked in the Columbia model, that you did, reach the justice and peace law and had agreement. And then the International Criminal Court decided it didn't need to step in because Columbia, had done its own domestic approach. But in general, I'm of the camp, no peace without justice. There's an NGO called No Peace Without Justice. And I don't see accountability as something you can negotiate away. I'm not a peace negotiator. I'm hoping it just doesn't arise, because in my mind, justice is coming, accountability is coming, and peace negotiations regardless. And certainly for the highest level and the most significant crimes would be my view.
Well, I hope you're right. I'd like to think you're right. I'm not quite sure how the ICC is going to get jurisdiction on President Putin if he stays in power, because they haven't been able to so far for the crimes he's committed elsewhere, from Syria to everywhere else. And I worry if you don't even put the word justice on the table, because there's going to have to be justice and reconciliation at some stage. Many Ukrainian people understandably now hate not just President Putin, but Russians for what they've done to them. And if you don't have some reconciliation between these two countries, you will have further violence. So I think putting the issue on the table at all would be a mistake, because then Russians would just say that means that no one cares about this. The same as reparations. If you don't even put the word reparations on the table, you may not get reparations. It may be the EU that's paying in the end, but you're not even playing that into the negotiation. So I'm not disagreeing with you about the need for justice. I'm just saying tactically, I think that would be a mistake. Can I just mention one other thing, which is specific to peace negotiations in particular, although I think it may actually also apply to the field that many of you work in, which is the actual mediation efforts and the shuttle diplomacy that's being involved in this. As I said at the beginning, we don't yet have a mutually hurting stalemate, but many states have tried to play the role of mediator, tried to be on the front foot in bringing the sides together. We've seen Israel talking to Putin, talking to Zelensky, trying to move things forward. We've seen Turkey actually convening now 2 meetings between the sides. Despite the happy words that came from Istanbul, I don't actually see any real advance there at all. But still, I think it's good that they're trying. And of course, France and Germany have tried as well. And a number of oligarchs seem to be trying, although difficult to know quite how serious that is. There will need to be, I think, some form of mediation in this conflict if we're going to get to an agreement. President Zelensky wants to have a meeting face-to-face with President Putin. And again, he's quite right to do that, because only when Putin says yes to something, given the dictatorship in Russia, will that actually be set in stone. But I think we have to hope that one or more effective mediator comes forward, because there's this hard work you need to do. Unlike in your legal context, you don't get arbitration, unfortunately, in these sort of conflicts, and you don't get a court case either, unless you get a court case on accountability and responsibility. But what you have to get is someone who can shuttle backwards and forwards, be patient, build up the trust, and actually get this into a state where you might be able to get to a settlement if Putin concludes that he cannot win in the terms that he wants to win, and if we can prevent him from getting to this frozen conflict, which may be his fallback. So I think we need to focus a little bit on this role of mediation, this role of shuttle diplomacy, that may gradually get us at the right moment into a successful negotiation that can spare the Ukrainian people, but not leave them in this frozen conflict, which means their suffering will go on for much longer.
Yeah, indeed. I know that some leaders of foreign states have already offered their services as mediators. But so far, as I understand, Russia has not agreed, and Ukrainians actually perceive the Russian negotiation rather as a play to their war attacks. So it's not like true will and wish to settle and to reach an agreement. I would like to move to another topic, which is quite close to what we have just discussed, and this is the issue of sanctions. So first, whether we need or could put it on the table. Second, whether we could, or not we, but it in order to, for instance, to make Russia pay the reparation or whatever whatever we call it, for the purposes of the negotiations and other settlement.
I mean, I could start it off here. I guess I would agree with Jonathan that reparations should be on the table. You know, how is all of this going to be paid for? And I saw a question in the Q&A, you know, could one use a UN Claims Commission model? Obviously, you can't use anything that would require the Security Council to authorize it. So we're somewhat limited. There's the possibility, of course, could, the Human Rights Council or another body that create a claims commission, or the General Assembly could certainly recommend one. So I think that, one could explore ways to create a claims commission, but you do have to get around the Security Council paralysis. Because there will be a significant issue of reparations. I know, Elena, you had the idea of, a future as part of the proceeds from oil sales, whether you could have like a percentage of the revenue. And I think this is kind of modeled on the oil for food program in Iraq, that at a certain point, Iraq was allowed to, first there was a blanket embargo on Iraq selling oil, but then there were, news of starvation. And of course, you have to make sure that, a UN kind of sanctions regime is not harming the individual, the populace of the country. So then they created the oil for food program. Iraq could sell oil if it bought food. So this would be kind of modeled on Russia selling oil, and a percentage maybe goes into a claims commission or something like that. And then, as one possible model. So I think that is definitely an issue that should be on the table.
Of course, our memory of reparations from Versailles, etc., not very happy in terms of ending conflicts for good. So we need to be careful in what we do on reparations. But I think it all falls into the category of the responsibility and accountability for what Putin has done, which should rest with Putin and those around him. So I think it should certainly be on the table, but I don't think we should be too optimistic about what will be achieved in terms of amounts of money. I think it will in the end be Europe that needs to pay for rebuilding Ukraine, and that may help in terms of bringing Ukraine increasingly into Europe, into the EU, which is something I think that's wanted. You mentioned sanctions too. In terms of sanctions, I'm pleased that the West has been more active than it was in 2014, which is really rather sad, the sanctions that were imposed then. But of course, the problem with sanctions is pain both ways. It's also a pain felt in our own countries for doing this. And the question will be how politically sustainable that pain is over a long period of time. And Germany and other European countries that are very dependent on Russian oil and gas have been very reluctant to increase the squeeze on oil and gas, because they say it would really create extraordinarily difficult circumstances for them, although we then end up in the bizarre circumstance of Europe actually paying for Putin's war effort. I think the real problem with sanctions is a bit like with Saddam, that sanctions hurt Russia, they hurt the Russian people, but they don't necessarily hurt Putin. Putin has enough money, I think, to survive without worrying too much about sanctions. So we need to find other ways to get to Putin, I think, because he's the one who's going to have to stop this war rather than the Russian people. So we should certainly not relax sanctions. And the thing about sanctions that's striking is they're much harder to remove than they are to put on, particularly American sanctions. And of course, UN sanctions are very hard to put on when take off when they're put on. So I think we should think about how we put a further pressure on Russia through sanctions, and how we can offer taking them off as a reward. But we cannot count on sanctions by themselves. They never have anywhere in the world been the answer to these problems. The answer, I fear, lies particularly in the extraordinary courage and ability shown by Ukrainian forces that are forcing Russian forces back. And I hope the solidarity of the rest of, at least of Europe and North America, although I have to say, if you travel around Africa, as I've just been, and elsewhere, that solidarity is not quite so marked in other countries behind Ukraine as it is in Europe and North America.
Maybe just related to that, I see the third question in the Q&A, and it asks, could you please comment on the potential of confiscating assets frozen in US, EU, and UK for the use of reparations? Yes, I think that is an additional potential source of funding that could be explored. We in the US had the precedent of Iranian assets after 1979 frozen in US banks, and there were significant negotiations about those. And as a result, the Iran-US Claims Tribunal was created in The Hague to resolve outstanding disputes. So we do have precedent of one who could potentially explore utilizing those assets.
Jennifer, perhaps on that topic, the ICC has a trust fund for victims. Can you tell us a little bit about that, how it was set up, and if it has a role?
Yes, absolutely. Thanks for that. I do think the trust fund for victims could play a role here. So just to say, so the International Criminal Court does the accountability, and at the end it can grant reparations, but unfortunately the cases take a really, really long time, and we often have victims in really dire situations in the meanwhile. Perhaps with that in mind, and they could apply for standing to be recognized as a victim, and maybe like years later might get something out of that. So that's not really ideal when victims have really pressing needs. So the trust fund for victims, which is separately funded. So the US has a current legislative ban on funding the ICC, but we actually could fund the trust fund for victims. It's a separate institution, and I'm hoping the US could actually do this. So the trust fund for victims kind of gets out there earlier on, and is somewhat doing good works in the ICC's name. It's active in several of the situation countries, and it will fund things like rebuilding community centers and rehabilitation programs, and trying to help the local populace in the area where we've had the atrocities, because the ICC is also somewhat narrow in recognizing who is a victim, and you actually have to be a victim of the claims alleged in that particular case in order to have recovery. And I think this causes vast disappointment. So, take, for instance, the first case, Thomas Lubanga, for use of child soldiers in Eastern Congo. Huge numbers of victims in Eastern Congo. And then they're told, well, you can't be a victim in this case unless you were a victim of these particular crimes. And of course, there's so many different crimes in Eastern Congo. It represented only this tiny subset. So that I think also the trust fund for victims is important in this respect because of the narrow way that the reparations seem to be working in individual cases. So it actually can get out there, what it can do is dependent. This does take voluntary contributions, and states could be contributing, and it's just another way to try to get out there and helping victims. Because ICC, International Criminal Court cases, just to be realistic, take a really long time. And don't prosecute that many individuals, which is why we also need other approaches, both to reparations and accountability.
Well, I think it's probably time to open it up to questions, both from our in-person audience, but also our audience online. Perhaps, Jennifer, to get started, I see the second question, I think, is also directed to you in relation to the Security Council.
Yes.
So maybe if you pick that up while people think about their questions in the audience.
So I like the thought behind the second question for anyone who isn't seeing it. Is there a room to argue Russia's not a proper member of the UN or UN Security Council due to the issue of its acceptance after the USSR collapse? So if you turn to the UN Charter, it actually says the Soviet Union holds the seat. It's an interesting issue to explore. I'm not having immediately positive reaction because I think in law we have this doctrine of estoppel. So we have since the fall of the Soviet Union treated Russia as holding the UN, being the UN member that holds the Security Council seat. Another reason I think it may be difficult to open this can of worms is if you look at the charter, it actually says the Republic of China holds the China's seat. So we also, it seems like we would be opening that can of worms. So I'm not immediately leaping to the possibility of doing this, which is not to say, there might not be some clever UN lawyers who are thinking about these issues, but I think we may have kind of waived both of those arguments by decades of practice.
there any questions from the audience? I would just encourage you to speak up so that they can hear. Okay.
Yeah, I must admit I quite liked Elena's idea about a tax for reparations. I thought of this idea of a tax on oil, and that seems quite a good idea. But one area you haven't talked about at all was the ICJ, for example. So the ICJ recently rendered an award on reparations of $325 million against Uganda for the unfair invasion of the DR Congo. Is there any potential for the ICJ to play a role, or even on reparations?
So I guess that is directed towards me. I guess there is potential. I mean, it's a little indirect because the suit was really was there genocide occurring in Donetsk and Luhansk that could have justified the Russian intervention. And of course, they know there was absolutely no genocide. It can't justify the intervention. So technically, I think it was a breach of or interpretation of the Genocide Convention case. I don't know if the court could reach reparations for essentially the aggression. I see it maybe as a little more indirect than the DRC ruling. So it's a possibility.
Yes, please.
Thank you. So thanks, Jennifer. That was really interesting, really helpful about how to limit the discretion of UN Security Council members when doing the veto. My question on this is, I mean, who would control whether a veto is excessive or a veto is violating international law? I mean, then would we go back to the International Court of Justice and asking maybe we could even rely on the Genocide Convention saying that you're violating the Genocide Convention because you're voting against your obligations under that convention. So that would be quite an interesting case then. I don't know, maybe you can expand on this.
Yeah, thank you so much for that question. Exactly. So I've thought of at least 4 ways to tee this up for the International Court of Justice. And one would be a generic question. So I would phrase it, does existing international law contain limitations on the use of the veto power by permanent members of the UN security in situations where there's ongoing genocide, crimes against humanity, and or war crimes? I might now rephrase my question to also include aggression, but there's actually a lot more precedent for limiting it to these 3 crimes. That's a whole separate question. We tend to treat the 3 crimes different from aggression, and maybe we shouldn't. So you could ask a generic question to the International Court of Justice. You could take a particularly egregious veto. Let's say there's a veto, there's ongoing genocide, there's a veto. So the problem is China uses this behind the scenes and uses veto threats. So you actually need courageous states to put issues to a vote, have China veto, and then you have the legal case. So if China is able, so in Darfur, they watered down the sanctions regime. They watered down the peacekeepers mandate. The water delayed peacekeeping. Peacekeepers arrived years after the Darfur genocide or the height of the killing is largely over. So you're often not seeing how China is using this leverage. But if you even got any case, I think it would constrain, you can't, if we could get a ruling that China couldn't make these veto threats because it would take away from the ability to veto in some of these cases. So you could have a generic question to the ICJ, a particularly egregious veto the General Assembly sends for an advisory opinion. So those would both be advisory opinions. Or you could have a contentious case under the Genocide Convention. If you had a clear veto in the face of genocide, you bring it under the genocide. However, 2 of our P5 have the reservation you can't sue them at the ICJ under the Genocide Convention, and China is one of them. I think the US is the other. Or you could have a suit under the Torture Convention. I know Netherlands and Canada are exploring a torture convention suit against Syria for torture in Syria. So suddenly the ICJ is being this venue. It obviously has the Gambia versus Myanmar case, looking at the crimes against the Rohingya, very clearly a genocide case as well. So suddenly the ICJ is maybe, it doesn't deal with international criminal responsibility, but state responsibility, and suddenly is doing these questions. So you could tee it up under the Genocide Convention or Torture Convention. However, 3P5 have that Torture Convention reservation. I think it's US, France, and China. Although it is interesting that in the DRC Rwanda case, 5 judges said we need to revisit the legality of that reservation to the Genocide Convention. You shouldn't be making a reservation. They felt it contravenes the object and purpose of the convention. And we need to revisit, deciding, okay, we agree we won't commit genocide, but please don't sue us over it. That is just too hypocritical. So at least 5 justices said we need to revisit the legality of that kind of reservation. So if you were to sue a country that has that reservation, it's a 2-step litigation strategy of first challenging the legality of the reservation. Thanks.
I had a question for Mr. Powell. I think it was Gillian Rackman of the FT who wrote last week that if one analyzes Russia's sort of strategic objectives, he said then one of the key things which the West seems to underestimate is the wish to root and to foment, sort of to plant seeds for future conflict. And he mentioned as an example the total destruction of Mariupol. He didn't mention Stalin, but he said, it's foreseeable that the Russians will repopulate Mariupol, and then together with Donbass, they will have a continued sort of a simmering pot for future ethnic conflict. And the implication of the article was that even if Ukraine will in the future be more embedded within the EU, if you don't take measures in the negotiation phase which cater for a resolution or the prevention of this sort of simmering ethnic conflict which Russia would poke on every time when it suits them, then you will never have serious peace.
Yeah, I think Gideon's absolutely right. What the Russians are looking for in these circumstances is to try and get to an open wound. They want to leave an open wound in place because they can then poke it and exploit it as they go forward. As I said, that's what they did in Georgia. It's what they've done in Moldova and elsewhere. So I think that's exactly what they'll be thinking about. If we can't win and take over the whole country, and I think we shouldn't underestimate what Putin's initial aims were. He fairly clearly thought he could take the whole country or he wouldn't have marched on Kiev. Now he's fallen back on this. I think he will be looking at how he keeps a frozen conflict going so that open wound is there. I think you're right too that what he's trying to do is stir up hatreds between Russian speakers and non-Russian speakers in the east of Ukraine. I think the actual impact he's had, as far as we can see, is to make those Russian speakers even more opposed to what he's doing than even the Ukrainian speakers. So it's backfired, as has much of the rest of his plan from that point of view. But if he can possibly get away with it, what he will do is not settle this, leave it unsettled as a way of stopping Ukraine moving down the European path that it wants to, and being able to grow economically and be a model to Russia of how a functioning democracy can work in these circumstances. I think that's exactly what he's trying to do. And I think it's very important the Ukrainian negotiators and the rest of the West are alive to that and make sure we don't end up in that situation again, which, by the way, is easier to say than to do in practice as a negotiator.
Just a follow-up question for Powell. Regarding like Donetsk and Luhansk and questions of like territorial integrity and sovereignty and autonomy, like how viable would you say is the model regarding Northern Ireland, and would that be something that's involved in the negotiations in terms of resolving disputes there?
I'm not sure the Northern Ireland settlement is directly applicable to the situation in the Donbass or even in Crimea. But it's interesting that the Ukrainian side, I personally think this was a mistake to indicate this, but have indicated they're willing to discuss over 15 years the status of Crimea. And that, I suppose, could be used by the Russians to discuss a condominium if they wanted to. At the moment, they're saying, it is Russia, we're not talking about it. What the Ukrainians, I think, are trying to get to is the idea you could have some sort of condominium. In the way, for example, in Hong Kong, many, many years ago, in the 80s, I was responsible for the negotiations with China on Hong Kong. And what we did there by having the joint liaison group was the Chinese had some say in what happened to Hong Kong for the 7 years before we handed over, and then we, for 7 years afterwards, had a similar say. So you can imagine some circumstances in which, for say, Crimea, you could have that kind of outcome. But at the moment, the Russians show no interest in that at all. They say Crimea is Russian, end of story. And as for the Donbass, those two republics should be independent and Ukraine should recognize it. Again, they've shown absolutely no willingness to negotiate on that. But I think maybe if we could get to some sort of settlement on the bigger issues, then there's always a reasonable way of talking about the territory. What you don't want to do is go back to Minsk, where again, the Russians set it up as a trap that meant that you could never get to elections and a genuine referendum on the future of those provinces because they were going to carry on occupying them and you couldn't have a genuine fair referendum in those circumstances. So again, one has to be really careful in these negotiations of unintended consequences, and particularly the sequence of steps that you agree to, which can end up being a very serious trap.
Yes, my question is Jennifer. You mentioned advisory opinion. Would you consider that it would be wise for Ukraine to seek advisory opinions against Russia as similar to those in the Palestine war, as it would allow Ukraine to get ICJ's views on wider international law norms and whether excessive uses of force by Russian Federation should be generally prohibited as not compliant with any norms of intervention and any public international principles? Would you consider it to be a possible avenue for Ukraine, better than Genocide Convention proceedings?
Jennifer, you're unmuted.
Sorry, I need Jennifer in the room to repeat the question because I didn't fully hear it. Sorry.
Yeah, so the question was whether Ukraine should perhaps be seeking an advisory opinion on questions of the use of force and whether that might be better than the route that has been followed through the Genocide Convention.
Yeah, no, it can't seek an advisory opinion. So under the UN Charter, the General Assembly and Security Council can seek advisory opinions. So those are the two bodies set up. You know, if there were a good question, I mean, Ukraine could say, General Assembly, please put it to the ICJ, was Russian aggression justified? I mean, that would be, you know, if they wanted to get some kind of ruling on the legitimacy, but they would have to have the General Assembly ask their question. Yeah, I mean, so that could be a route. So, but Ukraine can't ask directly. So we do have certain conventions that allow these kind of ICJ suits. Genocide Convention is one, Torture Convention is another. And it's not set up for under the War Crimes Convention. And we don't have a multilateral crimes against humanity convention. So those same kinds of questions can't be asked on those. A lot of the terrorism conventions have that provision. So there are, there are a number of conventions that you can use this. And you're actually asking, for kind of clarification how the convention applies in that situation. Our model is Bosnia versus Serbia for genocide. And we have the ruling from the ICJ. It is somewhat disappointing that it said Serbia didn't rule on Serbia's responsibility other than to say, but Serbia failed to prevent genocide as is required under Article 1 of the Genocide Convention. And in that aspect, it issued a very good ruling that states, based on their position of power and position of influence, have this obligation to prevent crimes. And I think we need to make much more use of this kind of ruling And this could be a basis for some of the challenges to the veto I suggested. There is actually all P5 then have an obligation to prevent genocide. And so some of their vetoes are being used in ways that are at odds with the Genocide Convention. But yeah, it's only the GA and Security Council that are set up under the Charter to ask advisory opinions.
Yes, but if to assume that there would be a General Assembly sort of united for peace resolution again, there is a chance that resolution could be. Would you consider it to be a fruitful avenue?
They could do this. I mean, we already have a GA condemnation that Russia has committed aggression. They could ask this of the ICJ. It's making kind of half of the crime of aggression case from a judicial body rather than a political body. So it is an additional legal tool. Ukraine has been very clever in harnessing legal tools. It is an additional legal avenue if the votes are there, but given the 141 in favor of saying that Russia has committed aggression, sending the same question to the ICJ, you would think the votes would be there, but there may be states that don't like that precedent of getting a judicial ruling if something's aggression. So I don't really know, the politics behind whether all the votes would line up, but it is a potential additional legal route that could be pursued.
Well, my question is, yes, given the fact that Putin is a very special figure himself, he has organized his life, I think, for all of his life, the rest of his life, and maybe the life of his family financially as well. Might there be any special legal vehicles, like maybe apart from sanctions, to be taken in this respect? And maybe some legal vehicles have already been sort of apart from the sanctions. Thank you.
Not sure who wants to, Jennifer, if you want to pick that up. Essentially,
I'm not sure. I think it might be Jonathan, who's more a sanctions expert. I think we've already, discussed sanctions can be this blunt tool. You don't really want to harm the people in Russia, unless it causes them to open their eyes to the leader they have. But given they're getting false information, it's a complicated situation. So one talks about smart sanctions. So you ultimately want to squeeze the head political figures and not harm the people. So, what are the message you can use? I know Jonathan did ask, how would you ever get Putin to The Hague? And, yeah, it is an issue, but, I a long time ago, I worked for Human Rights Watch, where we had an arrest Karadzic and Mladic campaign. And, at that point, we kind of thought, would they ever be in The Hague? And of course, they made their way to The Hague, as did Milosevic. And then I was there when we were looking at the situation of Charles Taylor, who was not, there'd been an indictment. So, never say never. And the other thing, if the court proceeds and issues a warrant for Putin's arrest, this is ultimately, while he remains in Russia, he couldn't be arrested. I mean, the court has no arrest capabilities. It relies on national jurisdictions to conduct arrests, but it would be a complete travel restraint. So, we had this issue of President Bashir of Sudan indicted for genocide and then traveling. And we finally got a ruling that state parties have an obligation to arrest him. And out of both the ICC and then a national court in South Africa, a litigation group after his travel to South Africa, got a ruling that South Africa, as a party to the ICC statute, should have arrested Bashir. It is more likely these high-level individuals are often tried when they are no longer in their positions. This tends to be how this has worked. But in the shorter term, it then becomes a travel impediment. And I would think this could be a potential travel issue for any Russian high-level political or military leaders. who should not be complacent in any travel if they're linked to atrocity crimes, war crimes, because we have not only the ICC out there, and some of these institutions have the capability of issuing sealed indictments. So just to say this exists. And we also have at least 8 national jurisdictions that have commenced criminal investigations. And they potentially could be issuing arrest warrants, although there it becomes more complicated because I think you have immunities questions.
And of course, Milosevic was only brought to justice because his own people toppled him after the Kosovo War. And I just wanted to end on a slightly more optimistic note than I've been fairly downbeat about things. It is interesting in these circumstances. We sort of get frozen in the moment and don't take into account the dynamism of things. So, for example, at the moment, people say, well, we need an off-ramp or a golden bridge for Putin. One doesn't exist. And the interesting thing about zones of possible agreement, the thing you're aiming for in a negotiation like this, is they're very dynamic. They can change during the course of a negotiation. You know, the IRA, when we were negotiating with them in Northern Ireland, had a constitution that said they couldn't give up their weapons until there was a united Ireland. In the end, we didn't even discuss a united Ireland. They negotiated peace on a different basis. So I don't think we should talk ourselves into complete gloom because of what the Ukrainians have done, because of the Western solidarity. I do think there is a prospect that this war will come to an end, and we might even, despite the horrors that have happened, end up in a better situation if we avoid this frozen conflict, and maybe even, as Jennifer is suggesting, see Putin in The Hague. Let's hope so.
Well, I think on that note, we're exactly on the hour. So I'd like to extend a very heartfelt thank you to our panelists. It's been fascinating for us hearing about justice and peace and hopefully how to reconcile the two. To our audience, both in person, but especially online. I know that many of our Ukrainian colleagues have joined online, and we're very thankful to have them participating. I think as international lawyers, we all appreciate that the path to justice can be long and can be difficult. But I think the bravery and the commitment that we've seen from the Ukrainian people in the current war has certainly strengthened our resolve to achieve that end. I'll open the floor to Elena, who might want to say a few final words, and of course invite you all to refreshments afterwards. Thank you.
Thank you very much for our speakers and our audience for this fruitful discussion. It is indeed important to find a legal way to make Russia accountable for the reasons I described in the very beginning of this event, not only as a matter of justice, but in order to prevent any such aggression and crimes again. I know that there are some leaflets in the audience providing different opportunities to help Ukraine in this war. So I invite all of you to look at it and to consider helping Ukraine in any way possible in this situation. We do need your help. We do need help on different levels, on international, on individual, on bilateral, and any help indeed matters. Thank you. Thank you for standing with Ukraine.
Thank you.
Thank you.